back to Wine and Chill, your home for all things legal shenanigans. I'm Stephanie, your friendly neighborhood lawyer. Well, not your lawyer, which brings me quickly to our disclaimer. By watching this video, you understand and acknowledge that this video is solely for entertainment purposes only, and you agree that you have read the full disclaimer down below in the description box. So, today's Wednesday, which means we are going to do a run-through of 3 quick lawsuits, and then you guys are going to get to vote, and then I'll give you the long-form version eventually. I feel like eventually is me being honest, because child, I'm behind, but I'm gonna get there. Last week, I know I only gave you 2, so this week, yes, I have 3 for you to vote on, and then 1 funny one, which doesn't count. Great. So today we are going full on entertainment law mode, which as a former entertainment lawyer, you guys know I love. So let's start first with Friday the 13th. That's the scary franchise that no, I do not watch because I'm terrified. So for Friday the 13th, there are actually 2 separate lawsuits, but they kind of will likely overlap. There was one that was just filed earlier last week, and there's another one that's been going on for a year. So let's take them in turn. So one is a Hollywood accounting, aka Tiffin Money, lawsuit, and the other one is a copyright lawsuit about who actually owns the rights to the franchise Friday the 13th. Both very interesting. So let's start with the Hollywood accounting, which is the one that was just filed. So Hollywood accounting is this infamous term that is coined because in Hollywood, and not just Hollywood, in movies in general, any type of production, the way the accounting done is not your normal standard accounting, which is you want to be profitable. You know, the more money you make, the better. Hollywood accounting didn't really work like that. So background, so that way it makes sense. In the TV, film, Broadway also industry, every film and every film that is on television, every Broadway play is most likely a separate legal entity. So it's either a corporation or LLC. So for example, if I made Stephanie the Musical, I can't sing, so this is a great fake example. Stephanie the Musical, that would be Stephanie the Musical Inc. Incorporated. I would hire people under that corporation to then do the work for Stephanie the Musical. Following? So the way that Hollywood accounting works, most of your favorite movies are actually on paper not profitable, which is interesting. For example, Lord of the Rings, allegedly not profitable. It is due on a basic level. It is more lucrative for the company, the corporation of the film, to not be profitable. Tax reasons, there are other reasons, and there are legitimate accounting gymnastics how the heck they get to those numbers. Child, y'all know how I feel about the math, so I don't get it. And you know who also doesn't get it? A lot of the producers, because they get super pissed off that they feel like they are being taken a fool for their money, and then they sue, which is what's happening Friday the 13th. So specifically, Sean Cunningham, he's the producer of Friday the 13th. He is suing for back pay, and then also saying that the licensing agreements he agreed to were withheld from him. He also stated like, hey, even if we look at these licensing agreements, they're not fair. So Friday the 13th is a huge horror franchise, has grossed in theaters hundreds of millions of dollars, but yet on paper is actually not profitable. How, Sway? How? So the way these licensing agreements are drafted, instead of saying, hey, Sean, his name is Sean, instead of saying, hey, Sean, if Friday the 13th hits $100 million in sales, you will get $10 million. It instead says, okay, Sean, you will get a percentage of the sales. So the percentage you're going to get is whatever percentage point you are going to license the rights to this movie, and then we'll give you a percentage of the sales. Okay, cool. That sounds fine. If you, from a business perspective, it will sound better at first to get the percentage because you're not capping yourself. You're like, oh, if it continues to gross more money, I'll continue to get more money. The problem being, and the problem why Sean is suing, is because if you're not profitable, that means you, as the licensor, the person who is licensing the material, is getting nothing. Zero, zilch, nada. So he's suing. So separate from that, he's also being sued, honey. So there is a separate copyright case that has been going on for about 2 years now, which Victor Miller, he's the writer and the original creator of Friday the 13th. He wrote the 1980s version. He then sold the copyright to Sean Cunningham and that group. Now he's trying to terminate the copyright sale and to get the copyright back, which he legally is technically allowed to do. So there is a 1976 copyright law, which basically states after 35 years, the original copyright owner who sold the copyright is allowed to terminate that sale and take the copyright back. It's to ensure that if you sold something and you're like, oh, hey, this is making a lot of money, actually I want it back, and so the law is like, okay, 35 years later, if it's still even worth anything, fine, you the creator can have it back. They're in a lawsuit because basically Cunningham is trying to say, oh no, Miller didn't sell me anything. He actually was an employee, so he really couldn't sell it. Like, we just did it wrong. That, I don't think that argument is going to fly, but if you pick case one for Friday the 13th, we'll do both because I think they're both really interesting to see what happens with franchises. You know, with famous movie franchises, how do you keep them living, breathing when the IP is technically so old? Like, Jason is over 35 years. Jason is like 45 years old at this point. Like, the actual IP of Jason, the actual copyright of Jason. So that's number one, if you want to vote for that. Now, number two, child, is just a mess. So, number two, have you ever heard of Evermore theme park? Crickets? No, neither have I. But you know why we're hearing about them now? Because they are suing Taylor Swift. They're suing her for trademark infringement because they have trademarked the name Evermore. That's the name of their theme park, and the title of her last album is also called Evermore. The minute I heard that, I was like, oh, the theme park must be broke. The theme park must be broke. After further reading, it may seem so. Who knows? So basically, the complaint alleged that Taylor used the theme park's name to promote her album. She named her album that. She then toured, she sold merch, etc., etc., and that infringed on their trademark to the name. First and foremost, the trademarks are very different. If you go on the USPTO website, which is United States Patent and Trademark Office, you can see literally the tens of thousands of trademarks that are available. Tens of thousands. For example, you could file Evermore, the jewelry line. You could file Evermore. This is not Evermore jewelry. I'm just giving you an example. Child, before they come after me. No, I got nothing. It all goes to Sally Mae. So Evermore would fall likely under theme parks, plush toys, things of that nature. Whereas Taylor Swift's trademark will fall under, you know, music merchandise, music album. They're very nitty-gritty specific. So multiple Utah newspapers then called out Evermore as a BS and stated, oh, that's interesting. They owe a lot of people in the valley a lot of money, allegedly. More than 20 construction liens, allegedly. Landscaping fees. If you're broke, just say that. So this lawsuit is likely getting thrown out, is very frivolous, and to be honest, is just annoying. It is highly unlikely that Taylor Swift even knew that this theme park in Utah, of all places, existed. Next. So last but not least, my former employer. So yes, my first legal internship was at Bad Boy Entertainment, just for context, but as always, I will be impartial. So Diddy is suing Global Brands Group and Sean John, if you are confused. So I know a few of you popped up in my DMs and it was on my list to do anyway. So if there's confusion, don't worry, we're gonna talk about it. And I personally hope we vote for either this one, which this is number 3, or the Friday the 13th one is also really interesting, I think. The Taylor Swift one is just not gonna go anywhere, to be honest. So but there's much more to look into here. So basically, Diddy is suing GBG Brands and Sean John. Now, if you're confused, why would Diddy sue Sean John? He doesn't own Sean John anymore. He sold Sean John in 2016. Sean John was a brand that he started 1998. He started Sean John, sold it in 2016 to GBG Brands. GBG Brands basically owns a bunch of clothing lines, different brands across the spectrum. So they decided that they were going to go into a partnership with Misguided. Misguided sells trendy clothes. So they did a line where, in partnership with Sean John, they used Diddy's likeness, allegedly, in the line. They then, according to Diddy's lawyer, fabricated a quote from him and then attributed the quote to him and ran an ad with his likeness in it. Multiple things they did. All under the guise that, according to the complaint, it came across as them wanting to try to insinuate that he's still running the brand when he's not. He sold it. The value in Sean John is the value of association to him, to be honest. People buy Sean John because he made Sean John. Now that it's owned by someone else, they are still trying to capitalize on that. So the confusion here is when you sell something, what rights are you assigning? So he's assigned the full trademark to Sean John. So they can use any Sean John logo, anything of that, but they can't use his likeness. Sean John never owned his likeness. Now they might argue and be like, oh, well, you know, your face was on etc. XYZ shirt. And that might be something that they argue. That's likely not a winning argument unless they reprinted that exact same shirt and then stated like, oh, this is a remake of whatever 2003 shirt of Sean John. Technically, yeah, because Sean John owns that. That would likely be a part of the Sean John IP, but just random photos of him, it's not gonna fly. Trying to attribute quotes to him, not gonna fly. Anything that says Sean Combs, likely not gonna fly because that's his actual name. Sean John is separate from Sean Diddy Combs. So this would be a really interesting case to go over trademark, right of publicity, assignment rights. What happens when, you know, as a creator, like you've made it and you're just like, okay, cool, that was like an awesome project that I loved, I adored for years, and I sold it off. I made my money off of it and I'm done with it. What then happens? How does it live on without you? And GBG is basically trying to recoup some money off of it, which it's hard. Usually those brands get put out to pasture because people only want to buy them if they're still associated with the brand. Our quick funny is from Matthew. Thank you, Matthew, for sending this to me. As always, you guys can send me funny ones or ones that you want me to cover. Super happy, which is really helpful, and I appreciate you guys for doing that. So our funny one is brought to you from Kenya. So this Kenyan woman decided after 8 years, she was tired of her boyfriend not proposing to her, and she sued in Kenyan court for him not proposing to her. And sis, don't let that man waste your time. You know what? Good for you. When I read it, I was like, you know what? Sometimes you need answers. And the only way to get answers is to push people. So I can't get into like the nitty gritty of the case because it is not in English. And unfortunately, I'm a limited human being. But it brings up an interesting point, which Mariah Carey famously put a breakup clause in her prenuptial agreement with her ex-fiance. I don't remember the man's name, some billionaire, and it basically stated if they didn't actually marry, he would have to pay her a certain amount, and they didn't get married, and he did. So there is value to your time. So that's the funny one. So you have 3 options today. One is going to be Friday the 13th, the copyright case, and the misappropriation of funds case, the licensing case. And then number 2 will be Taylor Swift versus Evermore and the trademark case. Number 3 is also going to be a trademark case with Diddy versus Sean John and GBG. And Misguided, he sued all 3 of them. He was like, listen, y'all want to play? Watch this. So those are your 3 options. Let me know in the comments which ones you want to vote for. As always, I appreciate you, and thank you for tuning in.